First schedule, part 1, clause 1. Name. Who can practice in the name of CA in practice? Practicing CA can allow CA in practice who is a partner, an employee who is a CA in practice to practice in the name of CA or CA firm. How to write clause in the exam. A CA in practice shall be deemed to be guilty of professional misconduct if he allows any person to practice in his name who is not a CA in practice or not in partnership or employment with him. Can a non-CA practice in the name of CA or CA firm? Answer is no. Can relatives practice? Answer is no. Can CA who is not in practice in the name of CA or CA firm? Answer is no. CA in practice but not employer partner. He also cannot practice in the name of CA or CA firm. Foreign professional cannot practice in the name of CA or CA firm. Next, clause number 2. Paying share of fees or profits. Practicing CA can agree to pay or pays or allows to deduct in the form of a share brokerage commission to members related to member of ICAI, members having prescribed qualification under Regulation 53A, and members of prescribed professional bodies, Regulation 53A, partner related to partner, retired partner, legal heir of the deceased partner should be specified in the partnership deed. This is for all the services rendered in India or outside India. Regulation 53A. Members of prescribed bodies, Indian professionals, ICSI, ICWEI or ICAI cost accountant, Bar Council of India, Indian Institute of Actuaries, Indian Institute of Architect, foreign professional bodies, membership or qualification as recognized under Section 29 by way of MOU and MRA. Next, members having prescribed qualifications, CS, CW or CMA, LLB, Actuary, Architect or BE or BTech, Engineer, MBA, established or recognized by law in India. Example, All India Council for Technical Education. Cases, CA paid 50% of the audit fees to employee under name of the office elements. Nomenclature is not important, not allowed. Obtain loan from finance company and agree to pay 6% interest and 10% of the gross fees till the loan is repaid, not allowed. Percentage of professional fees from audit of a cooperative society deposited to state government treasury to cover administrative cost, it will be allowed. And payment to sharing of fees with CPA or CFA, not allowed. With qualifications from foreign universities, not allowed. In partnership firm, partner dies, widow is paid share of profit. Such provision is present in partnership deed. It is allowed. Special case, transfer of goodwill. CA in practice, who is an individual or a proprietor, or all partners of the CA partnership firm, died. Legal heir can hand over practice to another CA in practice. CA cannot share fees or profit with legal heir as deceased was not his partner. CA can pay lump sum amount for purchase of goodwill from legal heir of the deceased partner. Installments should not be linked with future earnings. Procedure for of transfer of goodwill. CA in practice purchasing goodwill. Application to purchase goodwill should be sent within 1 year. Following should be sent along with the application: death certificate, succession certificate, or will or legal heir certificate, affidavit sworn by all legal heirs, draft sale deed, not signed agreement, draft sale deed, not signed agreement, clear payment terms for amount and time, no objection certificate of legal heir, newspaper advertisement to purchase goodwill, and copy to regional office. Form, file form number 18 within 30 days of the approval with ICAI time limit. Death has been happened on or after 10th August 1998. Within 1 year from death, till that time, ICA will keep name in abeyance, or in case of dispute within legal heir, which is submitted within 1 year. Time available is 1 year from the date of ending the dispute. Next, Regulation 53A, Indian professional bodies and foreign professional bodies. Regulation 53A is applicable to clause 2, 3, 5, qualification plus engineers or MBAs. This is applicable for clause number 2, 3, 4, 5. Regulation 54B, Indian professional bodies, foreign professional bodies. This is applicable for clause 4, entry of engineering professional bodies. This is allowed. Next, professional ethics important points. Partnership with MBA allowed. CA firms can have any number of partners. Every CA needs to maintain cost sheet. Areas which are exclusive for CAs, minimum fees is required. Areas not exclusive for CAs, minimum fees is not required. What is meant by CP? CP means continuing professional education. CA should not do needless publicity. Firm name is allowed in books, movies, interviews, appearance as per clause number 6 and clause number 7. But professional attainments are not allowed. CA should not highlight professional attainments. Firm name allowed in appearance as per clause number 7. A CA in part-time practice cannot sign and cannot train articles. Company can provide consultancy services. Company can be a partner in LLB. CA cannot be MD or WTD, but CA can become director simpliciter, provided special permission has been taken from ICAI. A CA cannot render portfolio management services, underwriting, broking services. A CA can be equity research advisor. Equity research advisor. Clause number 3, accepting share of fees. Allowed. CA in practice can accept or agree to accept share of fees, brokerage, commission from following members related points. Member of ICAI and members having prescribed qualification regulation under 53A, members of prescribed professional bodies regulation 53A, clause 1 and 2. First one is 53A clause 3, second one is 53A clause 1 and 2. Regulation 53A, same as clause 2. Referral fees. Referral fees. It means fees obtained by CN practice from another CN practice for referring client. It is allowed to pay and accept such fees. So referral fees is allowed. CN practice and lawyer paying 12% of the fees to each other. Allowed. Accepting share of fees from chemical engineer. Allowed. Accepting share of fees from travel agent or broker or doctor. Not allowed. Next, clause number 4, partnership. A CA in practice can enter into partnership with following: CA in practice, member of other professional bodies as prescribed in Regulation 53B, Clause 1, foreign resident who became member of ICAI into by way of MOU or MRAs, so that foreign professionals can become member of ICAI and vice versa, whose qualifications are recognized by central government or council for the purpose of partnership as per Regulation 53A. Regulation 53B, Subregulation 1. Member of foreign following professional bodies are allowed to enter into partnership: member of ICSI, member of ICWI, member of Bar Council of India, member of Institute of Actuaries of India, member of Indian Institute of Architects, member of Institute of Engineers, or engineering from a university established or recognized by law. Regulation 53A, Subregulation 3. People having following qualifications are eligible for partnership: CS, CWA, Bachelor of Law, Actuary, BR BTech, Bachelor in Architecture, MBA. MOU or MRA. Certain foreign professionals who are covered under MOU or MRA can become members of ICAI by appearing for few exams, and then they are eligible for partnership. Example: CPA Australia, CPA Canada, ICEW, etc. Partnership with foreign professional in India or outside India. It is not possible till they become member of ICAI under MOU or MRA. Multidisciplinary partnership. Though law has allowed it, regulators of other professionals are yet to permit it, and ICA has not issued guidelines yet. So practically, multidisciplinary partnerships are not possible right now. Number of partners. As per Section 464 of Companies Act 2013, as on today, limit for maximum number of partners is 50. But this limit is not applicable for professionals governed by special act. So CAs are governed by special act, so there will be no limit of number of partners in a CA firm. Next case, entered into partnership with uncle for doing textile business, guilty under clause 4 and 11. Clause number 5 secures work. Allowed, CA can secure professional work through partner, employee, not allowed to use means which are not open to CS. Ethical means are allowed, not prohibiting any agreement covered under clause number 2, 3, 4. Cases, agents on commission basis, not allowed, coercion, not allowed, bribe, not allowed, identifying mistake and blackmailing, not allowed, hacking government sites, not allowed, taking loan and instead of repaying, offering services in return, not allowed. Clause number 6, soliciting clients through advertisement, not allowed. Soliciting, that means asking clients for work either directly or indirectly by interview, advertisement, personal communication, circular, any other means are not allowed. Allowed, apply, request, invite, or secure any professional work from another CA in practice is allowed, can respond to tenders or inquiries by users of professional services or organization. Further, areas exclusively reserved for CAs apply only if minimum fees is prescribed. Areas which are open to other professionals also can apply irrespective of minimum fees. Clarifications on clause number 6. Hint is registrar bans violent movies and promote public counseling. First one, responding to tenders, advertisements, circulars. CA can respond to tenders and request made by users of professional work. Fees, condition based on areas exclusively reserved for CAs, audit and attestation services. Minimum fees should be prescribed in tender documents. Minimum fees should be as per nature, work, volume of work, and manpower requirements. Condition based on areas open to other professionals also. Accounting and internal audit, no minimum fees is required. EMD, EMD or security deposit, earnest money deposit or security deposit. ICA will not interfere with prevailing EMD or deposit requirements. If complaints are received for exorbitant EMD or deposit, Ethical Standard Board may look into the matter on case to case basis. Cost sheet, it should be maintained by CS when they respond to tenders. This cost sheet should include details of number of persons required, hours to be spent so as to compute overall cost. Then this information may be called by ICAI. Application for empanelment. Panel, court or government entities or banks or cooperative societies prepare and maintain panel list of CAs for allotment of audit and other professional work who can apply for empanelment. CS having knowledge about existence of panel can apply to get his name included in the panel. Roving inquiries. It means randomly applying to any of the above organizations without prior knowledge whether they maintain panel. Such things are not allowed. Quoting fees. CS are permitted to quote fees when inquiry is received from such organizations. Don't quote on your own. No menu card for fees is allowed. Greeting cards and invitations. Professional designation and qualifications are not allowed in greeting cards or invitations. Designation chartered accountant, along with the name of the firm, is allowed if greeting card or invitation are sent to relatives, friends, clients of the concerned member. Purpose, greeting card or invitations are for religious ceremony, for marriage, not self marriage, not others marriage, for opening of office, for change in office premises or telephone number. In such a case, designation chartered accountant along with the name of the firm is allowed. Introduction to client of another CA. Another CA started giving professional services to a particular client. Such assignment will be called original professional work. Now such CA introduced his client to us. Original professional work cannot be accepted by us if any other professional works is directly offered by client to us, then we should ask client to come through other CA who introduced us. CA should be informed and kept in loop. Sponsorship activities not allowed. CS are not permitted to sponsor an event. Allowed can sponsor event if two conditions are satisfied. Event conducted by program organizing unit of ICAI. Such event has proper approval by CP Directorate of ICAI. CP continuing professional education. CSR activities. Sponsoring such events are allowed provided only individual name with prefix CA should be given and no mention of CA name or CA logo is permitted. Here, firm name is not allowed, CA logo is allowed in case of CSR activities. Next, silver, gold, and platinum are centenary celebrations advertisement. Centenary celebrations advertisement. In general, CA cannot advertise events organized by CA or CA firms. But if event is in the nature of silver or golden jubilee or diamond jubilee or platinum or centenary celebration of CA firm, then advertisement can be published in newspaper or newsletter. Teaching or coaching or activities by CA. Such member shall take appropriate permissions as required by clause number 11 and regulation 190A. Member in practice should not put advertisement of coaching or teaching activities. It will lead to indirect solicitation or solicitation by other means under clause 6. Abstain from advertising their association with coaching or teaching activities through hoardings, banners, posters, and any other means. These are not allowed. He can put a signboard giving following details: the name of coaching or teaching institute, subject taught, contact details. It could be, it should be outside their coaching or teaching premises. Size should be as applicable to their name board. Here, CA name is not allowed. Roving enquiries. Roving enquiries are not allowed. Not permissible to address, letter, email, or circulate to people without any request or requirement from their side. It would tantamount to advertisement. Advertisement and note in press. Not allowed to advertise for soliciting work or any advertisement which can be interpreted as solicitation. Circulating letters to even to small field of possible clients is not allowed. Personal canvassing, door-to-door canvassing is not allowed. Next, following are allowed may advertise changes in partnership dissolution or change of address or telephone number. It is allowed give mere status of fact in newspapers or magazines and ensure appropriateness of area of distribution and number of insertions. Allowed classified advertisement in journal or newsletter of institute. Allowed for sharing professional work on assignment basis, for seeking partnership, for seeking salaried employee. Only accountant name is allowed, not firm name. Address, telephone number, email, social network site of the member can be given, can specify experience and area of specialization expected from candidates who are applying. Representation by auditor under section 140 subsection 4 of Companies Act 2013. Allowed, auditor can send his representation when CA is replaced as auditor. CA can explain in dignified manner that CA acted independently and consciously, that is carefully, throughout the term. CA may indicate his willingness to continue as auditor. Not allowed. Needless publicity. Not allowed. Anything which tantamount directly or indirectly to soliciting, boosting your work on internal control. Not allowed. Books or box number, articles or presentation. Box number advertisement is not allowed. Which is allowed? Can write designation chartered accountant, can write name of the firm. Firm name allowed. Professional attainments not allowed. Not allowed. Highlighting any professional attainments, whether of member or a firm, not allowed. Educational video allowed. Can upload educational nature videos on internet. Firm name not allowed. A reference to name of the firm should not contain any contact details or website details, website address. Sharing firm profile with prospective clients not allowed. Movies or television credits allowed. Name of the member or firm can be included in credits, not allowed. Exhibition of name differently as compared to other entries, that is names in the credit, not allowed. Share firm profile with prospective client, not allowed to share firm profile with prospective client. Which is allowed, it can be shared if it is in response to specific queries for prospect by prospective client. Sharing can be done with existing client without any prohibition. Giving public interviews. In case of public interviews, firm name is allowed, but professional attainments are not allowed. Allowed giving public interviews to press or all in any form. Name of the member or firm is allowed. Any detail given in response to specific questions, and they should be of factual nature only. Not allowed. Details should not be given in such a way which result in publicity or highlighting professional attainments. Seeking work from professional colleague. Allowed. Can seek work by professional colleagues. Personal communication such as meetings, calls, emails. Not allowed. Issue advertisement or circular for seeking work from professional colleagues. Case of clause number 6. Advertisement published in newspaper congratulating opening of new office, not allowed. In TV interview, biodata of the firm containing information like international standing, achievements, expert in field of taxation, etc., was handed over to chairperson, not allowed. Printing vision, values behind visiting cards, not allowed. Next, clause number 7, designation and achievement. A CA can advertise services provided through write up, provided it is as per guidelines issued by ICAI. Not allowed. Advertising professional attainments or services provided, use of any designation other than chartered accountant on professional documents, visiting cards, letterheads, or signboards. Clarification under clause number 7. Hint is front slaps DR Nene F. Mention of firm name except on professional documents. Can use firm name along with a designation, chartered accountant on professional documents like visiting cards, letterheads, signboards, under other circumstances as clarified by ICAI under clause number 6 and 7. Individual member can use prefix CA with name everywhere. Not allowed. Don't put designation chartered accountant at any other place such as pen, bags, keychains, etc. Here firm name is not allowed and designation is also not allowed. Next, size of signboard. Size of signboard should be such that it ensures appropriate visibility and illumination, lighting for proper visibility, access own discretion. That is ensure good taste. Not allowed. Glow signs not allowed. Lights on large signboards not allowed. As used by traders or shopkeepers not allowed. Residence. Name board of individual member with the designation chartered accountant is allowed. Name board of firm at house is not allowed. So at residence, firm name is not allowed. Logo, not allowed. Designing own logo of any kind or form on any document or material, not allowed. Monogram, written writing name in designer style, not allowed. Printing member or firm name in any manner tantamount to logo or monogram, not allowed. Allowed common CA logo allowed. All members may use whether in practice or not. That CA logo can be used by members in practice or not. Elements of CA logo. Rounded rectangle with white color background enhances look of logo. CA in blue color for creative knowledge integrity. Tick mark in green color for prosperity and harmony. Tick mark upside down symbolizes wisdom and value of profession. Next, appearance of CA on electronic media, including internet. Allowed appear on internet, films, television, radio, lectures at forum. Allowed may give names and describe themselves as chartered accountants. Firm name is also allowed. Firm name is also allowed. Specialized knowledge or questions relating to subject matter. Allowed objective professional view on topic under discussion. Allowed, not allowed. Following three times are Three types are not allowed. In case of any exaggerated claims are not allowed, comparison not permissible, promotion of him or his firm not allowed, important appointments are views of public importance. CA is appointed or is in the position of local or national importance. Example MP, MLA, chairman of committee. CA asked to give views on matters of local or national importance. Mention membership of ICAI allowed, aim to active suitable publicity for ICAI and its members generally allowed. Reference to professional firm not allowed. That means firm name is not allowed in case of important appointments or views of public importance. Next, seminars, training courses for staff. Holding seminars or training courses for his staff, for staff of other CAs, for clients and his staff. Allowed. Name of CA is allowed in booklet or document, but undue prominence should not be given. Firm name is not allowed in case of seminar or training course for staff. Next, public announcements with the details of directors. CA is appointed as director in a company. CA should specifically inform company regarding clause number 6 and 7 of first schedule to CA Act. CA should request company that prospectus or public announcement or communication mentioning his name and material consent to him should be first issued to him so that CA can approve it and then it can be published. Designation chartered accountant is allowed. Directorship held in other companies is allowed. What is not allowed? Not allowed in case of directorship. Expertise, specialization, and knowledge in any particular fields or other appellations or any other professional attainments not allowed. Firm name not allowed. Next, date of setting up a practice or year of establishment not allowed. Date of setting up a practice or establishment on letterhead and on other professional documents are not allowed. Reports and certificates. Report and certificates should be issued on the letterhead of the firm. It will bring notice of public in a greater and or lesser degree. Extent and manner of publication of certificates should be limited to what is necessary to serve its purpose, proper purpose. So, reports and certificates on firm letterhead is allowed. Notice in the press related to success in examination. Notice can be published in press for success in examination. Local newspaper can publish details of examination success, name, address, school, local background. Allowed. Details of examination passed or prize or place gained. Allowed. Name of the firm, name of the principal or town. Allowed. Not allowed. What is not allowed? Undesirable publicity of the firm or principal or article. Not allowed. Network firms, network guidelines. As per clause number 6 and 7, as clause 6 and 7 are applicable to CA and CA firms in same manner, it is applicable to network of CA firms also. Recent clarifications are cases with respect to clause number 7. Hint is Kia firms QR. K. Knowledge partner or thank you advertisement. Allowed. Name of individual member as prefix or suffix CA as knowledge partner. Allowed. Name of CA firm as knowledge partner. Not allowed. ISO certification. To obtain ISO certification. Allowed. Not allowed. Using expression like ISO certificate in professional documents like letterhead, visiting cards, signboard. Not allowed. Associates of CA firm. Not allowed to write associates of or correspondence of other firms on letterhead, visiting cards, professional documents. What is allowed? Can enter in association or firm network. But in such a case, you have to use words affiliate of network. Firms, what is allowed? If CA is in partner in multiple firms, name of all the firms can be given in letterheads, visiting cards, professional documents. Quick response code. What is allowed? Quick QR code is allowed to be printed. It can be printed, but it should contain only that information which is allowed in visiting card. Visiting card. Following are allowed on visiting card. Name, designation, chartered accountant or qualification, firm name, all firms where CA is associated. There are no restrictions. CA logo, address or email ID, website address, only name, don't use, please visit or click here. Quick response code, QR code, it should give only that information which is allowed as per clause 7. What are not allowed on visiting card? Year of establishment not allowed, photograph not allowed, any other logo not allowed, associates of some other firm not allowed, ISO certification not allowed, celebrating 75 years as per clause 6 and clause 7 not allowed, vision or mission of a firm clause 6 not allowed. Next, cases where both clause 6 and clause 7 are applicable. Common cases, hint is FB chroma. If firms issue circular to non-clients that partner in charge of one of the largest accounting firm has joined them now, they can take firms services not allowed. Banner with name of CA firm not allowed. Centenary celebrations etc. are allowed. Centenary celebrations are allowed. History, publishing book containing history to be distributed to clients, associates, well-wishers, and printing of words celebrating 75 years in the profession on letterhead and envelopes not allowed. Ranking, providing data to other entities so that they can rate and compare CA firms, determine their ranking not allowed. Offer document, professional attainments not allowed. Managing director, letter sent of managing director offering services and giving impression that such letter are sent to more organization to get work not allowed. A audience, CA was introduced to audience in conference as management expert, and at the end of the conference CA requested audience to come for services to him and also distributed his business cards not allowed. Next, clause number 8, communication with previous auditor. Communication with previous auditor, applicability of clause number 8. All the audits, voluntary audit, statutory audit, cost audit, concurrent audit, branch audit, government audit, environmental audit, quality audit. For all these audits, clause number 8 is applicable. It is not applicable. Clause number 8 is not applicable to bookkeeping, consultancy, certification, special audit under Cooperative Society Act and Income Tax Act, and also where outgoing auditor is not a chartered accountant. Example, where auditor is cost accountant. In such a case, clause number 8 is not applicable. Following are the steps. Step 1, offer or proposal for appointment received by CA. Step 2, communicate to previous auditor before accepting. Step number 3, reply received by previous auditor. Step number 4, after studying all important items, convey acceptance to the client. Step number 1, whether entity has informed previous auditor. If yes, okay. If no, inquire the reason for change of auditor. If no valid reason is there, it will be healthy practice not to accept the audit. That means even if audit is accepted, it will be fine. Step number 2, communication with previous auditor. Communication will be prior to accepting the audit. It should be in writing. Mode of communication, it should be such that CA should have positive evidence of delivery of communication delivered by hand against a written acknowledgement sent through a registered post acknowledgement due, acknowledgement of communication from retired auditor received from email address registered with ICAI or his last known email ID, evidence received from Udin portal, guidelines not yet issued, premises locked. On acknowledgement due, it is specified that office found locked, it will be deemed as delivered. No address found. Communication received with a remark, no such office exists, and address used is same as given on IC website, it will be deemed as delivered. Unless retiring auditor proves that letter was not properly served and he is not responsible for such non-service. If no or tax audit is conducted in the last year, communicate with the last auditor, whoever was the last auditor in any previous year. In case of special audit under IT Act, it is not mandatory but healthy practice to communicate with the statutory auditor. Death of previous auditor. No communication is required. Just get a letter confirming the death of last auditor from the entity. Next, Companies Act 2013. As per Companies Act 2013, concept of acceptance after appointment is removed, and instead concept of consent before appointment is introduced. So communication should happen before sending consent. So as per Companies Act, first we will take the consent. Second, appointment. Step number 3, reply from previous auditor. A responsibility of previous auditor to reply in writing. If CS does not reply, wait for a reasonable time and then go ahead with the acceptance. Reasons for non-acceptance of assignment. Non-compliance of Section 139 and 140 of Companies Act 2013. Non-payment of undisputed audit fees. Exception. Exception is in case of sick unit. Sick unit means unit registered for not less than 5 years and accumulated losses equal to or exceeding entire net worth. Issuance of qualified report. CA may accept if he thinks that attitude of retiring auditor wasn't proper and justified. However, if retiring auditor qualified it for good and valid reason is there, incoming auditor should refuse. Before 2006 amendment, incoming auditor could not accept assignment on lower fees. That is undercutting without valid reason because of clause number 13. But now it is allowed. So undercutting of fees is allowed even if not justified. Step number 4, acceptance letter sent to the client. Acceptance letter, it is sent after analyzing the reply or waiting for reasonable time period. In case of tight time schedule, CA may accept the audit on conditional basis subject to reply of previous auditor. It is clarified for government audits, including government companies, banks and branches. Silent about other audits. Let's not take risk. Let's assume it is not available for others. Next, clause number 9, requirements of Companies Act. Duty of incoming auditor. Auditor should first ascertain whether requirements of Section 139 and 140 of Companies Act 2013 have been complied with and then only accept appointment. Cases. CA was appointed as an auditor of a company, but CA declined to accept the appointment. So Board of Directors appointed another CA, other CA. Appointment is not completed because auditor has not accepted it. This is this is a case of no appointment, so it is not a casual vacancy. In this case, automatic reappointment will be applicable. If not possible, ask ROC. Action of BOD is not as per Companies Act 2013. Unjustified removal of auditor. Procedure to be followed while dealing with unjustified removal of auditor. First situation, own will. Auditor resigned or auditor does not offer himself for reappointment. Auditor shall send communication in writing to BOD of the company giving reasons thereof. If there are any professional reasons, BOD should be informed about professional reasons. Copy should be sent to ICAI. Obligation of incoming auditor. Obligation to obtain copy of such communication from BOD before accepting appointment. Situation. Second situation, against will. Auditor was willing to get reappointed but not reappointed. CA should file copy of letter of representation which was sent to management for circulation to ICAI. Obligation of incoming auditor to obtain copy of such communication before accepting appointment. Responsibility of ethical standard board. Ethical standard boards should review communication in situation 1 and 2 as discussed above. Ethical standard board may ask for more information from incoming auditor or outgoing auditor or company and then make a report for council of ICAI as necessary. Removal of auditor by government and other statutory authorities. Same procedure as discussed above in the situation 2 will be applied. Clause number 10, charging fees. Charging or offering to charge, accepting or offer to accept fees of professional employment contingent upon finding of result of such assignment are based on some percentage of profit. Not allowed. What is allowed? That percentage of fees or contingent fees is allowed in following exception circumstances as per regulation 192. First case is management consultancy services. In management consultancy services, it is allowed. Cooperative society audit allowed. Certain financial services allowed. Cost optimization services allowed. Debt recovery services allowed. Asset valuation services under direct tax and duties allowed. Liquidation services allowed. And receiver for realization of assets allowed. Other services as prescribed by council. In such a case also, percentage or contingent fees allowed. Recently, council prescribed following services: acting as insolvency professional, non-assurance service to non-audit client, other than services specified above. In such a case also, percentage fees or contingent fees allowed. Fees in percentage basis in case of recovery in banking sector allowed. Fees in percentage of loan sanction not allowed because ICAI is yet to explain which services will come under certain fundraising services. Fees in percentage of value of goodwill not allowed. Engaging assignment on success fees basis. Success fees basis only if assignment give results. This is contingency, so not allowed. Percentage of valuation under gift tax act allowed. Charging fees in percentage of value accounting bills supplied to clients for saving tax. This is a misconduct under clause number 10, part number 1 of first schedule, and clause number 2 of part number 4 of first schedule. Clause number 11, engaging in business or occupation. CA can engage CA can engage only in CA profession, which generally covers accounting, auditing, tax consultancy, cost finance, consultancy, management consultancy, etc., permitted by council. Apart from above, CA can perform other activities as permitted by council, Regulation 190A and Regulation 191. Directorship. A CA can become director in a company, not a managing director or whole-time director. So a CA cannot be a managing director or whole-time director in a company, provided CA or his partner should not be auditor of a company. Next, Regulation 190A. Permission generally granted generally. That means general permission from ICAI Council. CA can engage into following activities without any specific permission from the council. That means general permission is taken. Hint is serve camel in pain. S. Acting as surveyor or loss assessor under Insurance Act. E. Employment under CA or CA firm in practice or recovery consultant in banking sector. V. Valuation of paper setter, head examiner or moderator for any exam. E. Editorship of professional journal. C. Attending class and appearing in any exams, articleship of CS. A. Authorship of books or articles. M. Holding public elective office, MP, MLA. E. Honorary office of charitable education institution. L. Holding life insurance agency license only for limited purpose of getting renewal commission. P. Private tutorship. A. Owning agricultural land and carrying agricultural activities. I. Part-time tutorship under coaching organization of institute. N. Notary public, justice peace, special executive magistrate. For all these cases, general permission is required from ICAI Council. Specific permission cases. Cases where specific permission is required. Specific permission prior approval from the council is required in following cases. First one, part-time or full-time lectureship for courses other than those relating to our institute examination conducted under the auspices of the institute or the regional councils or their branches. Apart from those discussed here, other business or occupation for which the executive committee considers that permission may be granted. Full-time or part-time employment in non-business concern, full-time or part-time employment in business concern, provided that the member and or his relatives do not hold substantial interest in such concern. Part-time or full-time tutorship under any educational institution other than the coaching organization of the institute. Interest in family-owned, family business concern or concern in which interest has been acquired as a result of relationships and in the management of which no active part is taken. Interest in any educational institution, office of managing director or whole-time director or body corporate within the meaning of Companies Act 2013, provided that the member and or any of his relatives do not hold substantial interest in such concern editorship of journals other than professional journals. So specific permission is required. Council may refuse to give permission in individual cases, even if it is covered in list of specific permission. Regulation 191, part-time employment as CA in practice may accept. So a part-time CA employee who is in practice may accept administrator, liquidator, receiver, arbitrator, advisor, or representative for costing, financial taxation matters, trustee, executor, appointment by central government, state government, or court, act as secretary. Provided all above arrangements should not be on salary come full-time basis. Next, part-time practice. CS doing following activities will be considered in part-time practice. CS who have taken specific permission for any activity as discussed above will be considered in part-time practice. CS who are in employment in CA or CA firm under general permission will be in part-time practice. CS who are involved in teaching in the form of private tutorship, part-time tutorship under CA institute, part-time or full-time tutorship under coaching organization or lectureship will be considered in part-time practice if teaching hours exceeding 25 hours a week. CA in part-time practice will not be allowed to perform attest functions, signing reports, certificates, and they will not be allowed to train articles. Relative. Relative means husband, wife, brother, sister, any lineal ascendant or descendant of CA. Substantial interest. In case of company, 20% or more of the voting power at any point of time is held by CA or relatives or any concern in which they are having substantial interest. In case of other concern, 20% or more of the profits are entitled to CA or relatives or any concern in which they are having substantial interest, deemed to be MD or WTD. When a person is not designated as MD or WTD, he can be deemed MD or WTD if he is interested in whole or substantially the whole of the management of affairs of the company. Clarifications issued under clause number 11. Director. Director or simpliciter, that means ordinary or simple director who is not a whole-time director or managing director, who attends only board meeting and not paid any remuneration except fees for attending such meeting. Permission. No specific permission is required from ICAI as this thing is allowed in clause itself. Provided CA or his partners are not auditors in the company, and it is fine if relatives hold substantial interest in the company. Can auditors of subsidiary company become directors of the holding company? Ethical Standards Board has clarified that auditor of subsidiary company cannot become auditor of holding company as if it will affect the independence of auditors. Promoter or promoter director. CA can become promoter or promoter director of the company. CA can be signatory to MOA or AOA of any company. Next, member in practice in HUF doing business. CA can hold interest in HUF provided that CA is not actively engaged in managing the particular business. Provide evidence that interest in family business devolved on CA as a result of inheritance or succession or partition of family business. Show that CA was not actively engaged in carrying on the business. Prove that this business was not created by himself. Furnish in prescribed format documents acting as evidence to concerned decentralized office of ICAI. CA can acquire interest in the firm's family business in following form: as a proprietor firm, as a partnership firm, Karta, or member of HUF. Trading activity by CA in practice. Equity or derivative trading in personal capacity allowed, but in professional capacity on behalf of the clients, it is not allowed. Commodity derivatives are not allowed in any capacity. So CA cannot trade in commodity derivatives in any case. Cases under clause number 11. Guilty of professional misconduct, doing business without permission, guilty. Becoming executive chairman without permission, guilty. Becoming employee without permission, guilty. Becoming LIC agent, guilty. Becoming partner of brother in business without permission, guilty. Becoming full-time lecturer in college without permission, guilty. Doing trading in commodity derivatives, which is not allowed in general permission, guilty. Next, clause number 12, signing financial statements. Who can sign balance sheet, P&L, financial statements, or report on behalf of CA in practice or firm? Person should be CA in practice and he should be partner of the firm. As per section 26, non-CS should not sign on behalf of CA in practice or a firm of CS in practice. No forgery. Meaning of the term financial statements. All reports and certificates which are issued after examining financial statements or books of accounts. It will also include any document attested, signed, or confirmed as per statutory requirement. Power to sign routine documents can be delegated. Example, issuing audit queries, issuing questionnaires are issuing questionnaires, making observation on draft financial statements, routine correspondence with client, initiating and stamping vouchers, issuing acknowledgement for records received, raising bills, attending tax matters on behalf of the principal. Next, first schedule, part 2, professional misconduct in relation to CS in service. Clause number 1, what is not allowed? A CA in service is not allowed to pay or allows to pay or to deduct or allows to deduct any share in emoluments of the employment. Allowed. What is allowed? Sharing of emoluments among relatives, friends, dependents. It will be considered as application of income provided such sharing is not related to procuring or securing the job. Clause number 2. What is not allowed? A CN service. There is a company which is making payment to advocates or agent or broker or CA, other CA or customers. CA employee should not accept or agrees to accept any share of such payment which is made to specified person, part-time or full-time employment. This clause is applicable to CS irrespective of part-time or full-time employment and irrespective of whether they are having COP, certificate of practice. Cases accepting referral fees from lawyer appointed by this company by a CA who is employee of the company is not allowed. Next, first schedule part number 3, professional misconduct in relation to CS in general, either in practice or in service. Clause number 1, CA who is not a fellow chartered accountant should not represent or act as a fellow chartered accountant. Next, clause number 2, professional misconduct. If CA does not supply information or does not comply with the requirements of ICAI, Council of ICAI, Quality Review Board, committees, appellate authority, disciplinary committee, board of discipline, disciplinary directorate, he will be guilty. Cases, even after various letters from ICAI, CA does not supply information about his non-CA proprietary firm business and his directorship in a company. Guilty. Even after request from ICAI, CA fails to explain how he is training article without having COP. Guilty. Even after instruction of ICAI, CA did not fill columns in COP form which ask for information in respect of other business or communication. Guilty. Clause number 3, not allowed. While responding to tenders or inquiries or asking work from another CA in practice, allowed as allowed in clause number 6, cannot give false information. If false information is given, guilty. While advertising through write-up as allowed under clause number 7, should not give information knowing to be false. If he has given the false information, guilty under this clause. Part number 4, other misconduct. Clause 1, convicted by court, imprisonment less than 6 months, guilty. Clause number 2, bringing disrepute to ICAI based on past decided cases, guilty. Guilty of other misconduct.